few cases that I've done as bench trials, and they have been few, and there's a reason for that. There's popular wisdom that a defendant would always rather have a judge than a jury. I don't believe that. So when I have a defense client, big corporation, I tell the general counsel or the president or the chairman that here's what you need to consider. If we get the right judge, and the judge has the same mindset as we have and identifies with us, great, wonderful, piece of cake. It's hard to figure out whether you have the right judge, and I'll speak to that in a moment. But with a jury, you have 12 people who have different experiences, they come from different places, and so it's less likely that you will have all of them with some bias that they share uniquely. So to me, with the right trial lawyer and the right client and the right story and the right preparation, a jury is more, there's a better chance of winning over a jury rather than having one person who may just have a bias that you can't know about and don't know about. So I push juries. I believe in juries. I think juries are the best decision makers for big corporations as well as for individuals. But if I have a bench trial, and for whatever reasons it's not a case which you have a right to a jury or people have waived, I do research on the judge. I read the opinions of the judge to try to figure out, to learn as much as I can about what this judge may be bringing to this particular case from past experience. So I read the judicial profile just to see, do we have a Republican or a Democrat? Do we have, often you can tell, are they Catholic because they went to Loyola or something. So as much information as you can get about the judge and the personality of the judge, and then I do read opinions that would be relevant to the issue that's before the judge. May not be exactly the same situation, but I try to get a feel for where that judge has been before. Sometimes you learn when you do that the judge is, yep, he's heard that or she's heard this case before and didn't go your way. But at least you know this is the mindset that the judge has, so that's what I have to deal with, so that you can be prepared to try to package the argument in a way that's going to persuade the judge this time, even if they went a different way before. When you have a judge trial as opposed to a jury trial, there's a number of different aspects that you have to consider that inform your approach. So a jury, I'm going to take state court, 12 people who form a collective mind. They debate together, they talk together, they have uncommon experiences, they have common experiences. So you have a creature that is created for that one experience, who usually those people have not had experience with the fact scenario that you're presenting or the law that you're presenting to them. So you do have to bring the level of the discourse to a level that everybody on your jury can understand. And that doesn't mean to be condescending, but it also means you don't want to use four-letter words. That would be a good thing not to use, but four-syllable words either. You want to keep it in a comfortable, expressive vocabulary. Judges, on the other hand, are completely different animals. First, unless you have a judge who's just been appointed to the bench and is sitting for his or her first trial, you have somebody that thinks they know a lot about what you're going to present. There's been a whole history with that judge. There's been cases that have been presented to that judge before. There have been arguments made that you had no chance to hear, much less answer. So there's a lot that goes on in the mind of a judge that can affect the outcome that the lawyer won't know, and you just have to take that. You have to take that as a given. Jurors like stories and the dramatic. Judges like to pretend that they don't. So if you treat a judge like he was a jury or she was a jury, you will often get from the bench, counsel, save that for the jury. Save that for a jury. I'm not a jury. Just get to the point. Don't tell me, you don't need to cite Shakespeare to me. Just just tell me the facts, ma'am.